Hello everyone, welcome to the U.S. Visa Tracker. In a development that has sent shockwaves through immigrant communities across the United States, new deportation rules targeting green card holders have been officially confirmed for implementation in 2026. This marks a significant shift in how lawful permanent residents are treated under U.S. immigration law, and the implications are far-reaching. Millions of green card holders who believed their status offered substantial protection from removal are now facing a reality where certain actions or circumstances could lead to deportation proceedings. The question on everyone's mind is simple yet profound. What exactly are these new rules? Who will be affected? And what can green card holders do to protect themselves? If you are interested in this topic and liking this video, please stay tuned until the end of the video. We'll break down everything you need to know about these changes, including specific triggers for deportation, the legal framework behind these policies, and practical steps to safeguard your permanent resident status. Now let's get into the video. In a recent development that immigration attorneys are calling unprecedented in scope, the Department of Homeland Security has finalized regulations that expand the grounds upon which lawful permanent residents can face removal proceedings. These rules, set to take effect on January 1, 2026, represent what many experts describe as the most comprehensive overhaul of green card holder protections in decades. According to sources within immigration enforcement agencies, the new framework will create additional categories of deportable offenses while also strengthening the government's ability to revoke permanent resident status for what officials term as threats to national security and public safety. The administration argues that these measures are necessary to close loopholes that have allowed individuals with green cards to engage in activities contrary to American interests without facing consequences. However, immigration advocates warn that the broad language used in these regulations could sweep up otherwise law-abiding permanent residents who make minor mistakes or find themselves in difficult circumstances. What makes this case different is the extent to which these new rules reach beyond criminal conduct. Traditionally, green card holders face deportation primarily for serious criminal offenses, fraud in obtaining their status, or extended absences from the United States. While these traditional grounds for removal remain in place, the 2026 regulations add several new categories that have immigration experts deeply concerned. Reports suggest that the expanded deportation triggers include failure to properly report changes in address within the required 10-day window, acceptance of certain types of public assistance beyond previously established thresholds, and what the regulations describe as patterns of behavior inconsistent with lawful permanent residence. This last category is particularly troubling to legal analysts because of its vague and subjective nature, potentially giving immigration officers broad discretion in determining who meets this standard. Let's take a closer look at who exactly will be affected by these new deportation rules. The regulations specifically target several categories of green card holders, and understanding whether you fall into any of these groups is crucial for protecting your status. First, permanent residents who have received any form of means-tested public benefits for more than 12 months within a 36-month period may now face deportation proceedings under the expanded public charge grounds for removal. This represents a significant departure from current policy, where accepting public benefits after obtaining a green card generally did not trigger removal proceedings. The new rules effectively create a post-admission public charge test, something immigration law has not historically included for lawful permanent residents. Second, green card holders who fail to comply with selective service registration requirements, even if they were unaware of the obligation, could face removal proceedings under the new regulations. This particularly affects male permanent residents who obtained their green cards between the ages of 18 and 26, but never registered with selective service. According to immigration experts, This provision could impact tens of thousands of green card holders who simply did not know about this requirement or believed it did not apply to them. The administration claims this provision enforces a long-standing legal obligation, but critics argue that deportation is a disproportionate consequence for what is essentially an administrative oversight. Third, the regulations create a new category targeting permanent residents who have spent significant time outside the United States without obtaining a re-entry permit. While current law allows green card holders to face abandonment proceedings if they remain outside the country for more than 1 year without permission, the new rules lower this threshold significantly. Under the 2026 regulations, spending 6 months or more abroad without demonstrating strong ties to the United States could trigger a review of whether the individual has abandoned their permanent residence. Immigration officials argue that this change simply codifies what green cards are meant to represent: permanent residence in the United States, not a convenient travel document for people who primarily live elsewhere. However, green card holders with family obligations abroad or those who travel frequently for work are understandably anxious about how this provision will be applied. In addition to these changes, the new regulations substantially expand the criminal grounds for deportation. While aggravated felonies and crimes of moral turpitude have long been deportable offenses for permanent residents, the 2026 rules broaden these categories considerably. What this translates to is that certain misdemeanor offenses that previously did not trigger removal proceedings may now be considered deportable offenses. For example, domestic violence charges, even those that result in deferred adjudication or pretrial diversion programs, could now lead to deportation proceedings. Similarly, drug-related offenses that many states have decriminalized or reduced to minor violations remain federal deportation triggers under the new framework. Immigration attorneys note that this creates a particularly challenging situation in states where marijuana is legal for recreational use, as green card holders could face removal for conduct that is lawful under state law, but still violates federal immigration provisions. The landscape of immigration enforcement has also shifted dramatically in how these new deportation rules will be implemented. The regulations grant Immigration and Customs Enforcement significantly expanded authority to initiate removal proceedings against green card holders without the additional layers of review that previously existed. In practical terms, this means that ICE officers will have greater discretion in determining which cases to pursue and will face fewer internal checks on their enforcement decisions. The administration claims this streamlines a process that had become too cumbersome and allowed individuals who should be removed to remain in the country indefinitely. Legal analysts suggest, however, that reducing oversight could lead to inconsistent application of the rules and potential violations of due process rights. Despite these challenges, there are some important protections that remain in place for green card holders facing removal proceedings. Permanent residents still have the right to appear before an immigration judge, present evidence in their defense, and be represented by an attorney at their own expense. Additionally, certain relief options, such as cancellation of removal, may be available for green card holders who can demonstrate they have been lawful permanent residents for at least 5 years, have resided continuously in the United States for 7 years, and can show that removal would cause exceptional and extremely unusual hardship to a U.S. citizen or permanent resident family member. However, before jumping to conclusions about the availability of these protections, it's important to understand that the burden of proof has increased substantially under the new regulations. Green card holders seeking relief from removal will now need to provide more extensive documentation of their ties to the United States and demonstrate their positive contributions to their communities. Beyond the immediate deportation risks, the administration has also implemented enhanced monitoring requirements for certain categories of green card holders. Those deemed to be potentially removable under the new provisions may be required to report regularly to ICE offices, submit to electronic monitoring, or provide detailed information about their employment, residence, and travel plans. Immigration experts note that this creates a two-tiered system of permanent residence where some green card holders enjoy the full benefits of their status while others exist in a state of quasi-supervision reminiscent of criminal probation. Advocacy groups warn that this approach fundamentally undermines the concept of lawful permanent residence and creates an atmosphere of fear within immigrant communities. While there have been some modifications to the original proposed regulations following the public comment period, the core provisions remain largely intact. Over 45,000 comments were submitted during the notice and comment phase, with the overwhelming majority expressing opposition to the expanded deportation grounds. However, officials argue that national security and public safety concerns outweigh these objections. The final regulations did include some clarifying language regarding the public benefit provisions and added certain exceptions for refugees and asylees. But immigration attorneys characterize these changes as minor adjustments that do not address the fundamental problems with the policy. To put this in perspective, legal permanent residents currently number approximately 13 million individuals in the United States. While not all of these green card holders will be immediately affected by the new rules, the expanded grounds for deportation create potential vulnerability for a significant portion of this population. Immigration experts estimate that anywhere from 500,000 to 2 million permanent residents could theoretically fall within one or more of the new deportable categories, though the actual number who will face removal proceedings depends largely on enforcement priorities and resource allocation within immigration agencies. The uncertainty itself has created considerable anxiety within immigrant communities, with many green card holders seeking legal consultations to assess their individual risk profiles. Here's what you need to know if you're a green card holder concerned about these new deportation rules. First and foremost, compliance with all immigration requirements is more critical than ever. This means ensuring your address is updated with USCIS within 10 days of any move, maintaining continuous residence in the United States without extended absences, and obtaining a re-entry permit if you must travel abroad for more than 6 months. Second, avoid any criminal conduct, no matter how minor it may seem under state law. What might be a simple misdemeanor in your jurisdiction could trigger federal immigration consequences under the expanded deportation grounds. Third, be extremely cautious about accepting any form of public assistance. While the humanitarian argument for helping families in need is compelling, the new regulations create real risks for permanent residents who rely on government benefits. The real question is what happens next and how these policies might evolve. Legal challenges to the new regulations are already being prepared by multiple immigration advocacy organizations, and several states have indicated they may join lawsuits arguing that the expanded deportation grounds exceed the government's authority under existing immigration statutes. These legal battles could take years to resolve, and in the meantime, the regulations will be in effect and enforceable against green card holders. Additionally, the political landscape surrounding immigration remains highly volatile, and future administrations could potentially modify or rescind these rules depending on their policy priorities. However, relying on potential future changes is not a viable strategy for protecting your current status. For families with mixed immigration status, these new deportation rules create particularly acute concerns. U.S. citizen children whose parents are green card holders face the prospect of family separation if the new provisions are aggressively enforced. Immigration attorneys are advising mixed status families to develop contingency plans, including designating guardians for minor children, organizing important documents, and consulting with legal counsel about potential relief options. The emotional toll of living under these circumstances cannot be overstated, and mental health professionals working with immigrant communities report significant increases in anxiety and depression related to immigration uncertainty. As a green card holder, this situation might feel overwhelming and frightening. The stability that permanent residence once represented seems less certain under these new regulations. However, knowledge is power in navigating these challenges. Understanding exactly what the new rules require, what actions could trigger deportation proceedings, and what protections remain available gives you the best chance of maintaining your status and protecting your family. Staying informed about developments in immigration policy, maintaining meticulous records of your residence and travel, and seeking qualified legal advice when questions arise are all crucial steps in safeguarding your permanent residence. It remains to be seen how aggressively these new deportation rules will be enforced once they take effect in 2026. Immigration enforcement agencies operate with limited resources, and historically, enforcement priorities have varied significantly based on policy directives from political leadership. Some immigration experts believe that the actual impact may be more limited than the regulations suggest on paper, focused primarily on individuals who also have criminal histories or other aggravating factors. Others warn that the broad language in the regulations creates potential for widespread enforcement actions that could affect hundreds of thousands of otherwise law-abiding permanent residents. That's all we have for this bulletin. The U.S. Visa Tracker channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.